Good morning, distinguished panel, guests, Generals Davis, Gelzo, and Rutstein, professors, and fellow students. I'm Pete Burrill, Symposium editor of the Connecticut Law Review, and on behalf of the Law Review, I welcome you to the 1999 Wiggin and Dana Symposium. Today we'll be discussing this year's other trial of the century, United States versus Microsoft. In 1998, the United States Department of Justice and 20 states' attorneys general brought a civil antitrust action against one of the most powerful and successful companies in American history, Microsoft. Although this is not the first time the government and Microsoft have litigated antitrust issues, this case may have the potential to be the most significant. The comparisons have been drawn between the Microsoft case and the Standard Oil case from the beginning of the century, with Bill Gates being cast as the modern John D. Rockefeller. While Microsoft critics fear that if unchecked, Microsoft will become the gatekeeper of the Internet with the dominance of its web browser, Microsoft defenders fear that a government victory in this case will ruin an American success story and suppress innovation in the software and computer fields. At the present time, the trial is in the middle of a 6-week hiatus, and rumors of a possible settlement are afoot. Now, before I pass the mic to Dean McGill, on behalf of the Law Review, I wish to thank the law firm of Wiggin and Dana, whose generous support has made this event possible. I'd also like to thank our wonderful panel, to whom you will be introduced shortly, as well as individually, our moderator Bob Langer of Wiggin and Dana and Professor Orland. Their guidance has been invaluable in putting together this symposium. So without further ado, Dean of the Law School, Hugh McGill.
Thank you, Pete. I want to add, on behalf of the entire school, our welcome, our thanks to Wiggin, our thanks to the panelists, and our thanks to you, Pete, and Lisa, and the Board of Editors of the Law Review for the remarkable number of entirely uncompensated hours that you put into putting this one together. It's excellent training for next year, where somebody may actually pay you for the work once they know that you're accustomed to doing without a great deal of sleep. Very, very, very reassuring to employers, I think. I have to admit to some institutional bias with respect to the litigation, the discussion of today's, the subject of today's discussion. My secretary said as I was coming over here, don't let them let Gates get away with it. As I will stop by or going in and out of the office, she will be sitting in front of her computer with her shoulders slumped, despondently trying to get the machine to do something, and she can't figure out how to, and it's now known in the office as a Bill Gates moment. But rising above the general principle, this is a wonderful opportunity, I think, intellectual nature for the panelists, participants, the audience, and for this academic community. I am old enough, and indeed many of the people in this room are old enough, to remember that period when antitrust law seemed to be about to be subsumed into legal history. We had, and still do have, 2 specialists in antitrust law in the faculty. We were thinking of letting one of them go because there simply wasn't any antitrust litigation. That has changed. I understand that there's some anxiety that a settlement may be announced in this case, even this morning. Don't worry, orders have been given throughout not to accept any calls from Washington, and if it does happen, you won't know about it until the day is done. But in an important sense, it almost doesn't matter whether this case is settled or not, because the issues that it raises and the problems that it involves, not only in antitrust law, the technical area of legal specialization, but also the economic phenomenon of Microsoft, and the relation of legal regulation to entrepreneurial activity, whether regulation in any form, be it through litigation, be it through legislation, is always going to be a day late and a dollar short, is one of the problems that as a society we must continually consider, reckon with, and ponder. Settlements come, settlements go, cases are brought, cases are won, cases are lost. The problems, however, which they reflect, abide. And even if you are mooted as to this case in the course of this very day, there is still so much to worry about, so much to think about, and so much to consider that this will have been a perfectly splendid opportunity for us all, even if Bill Gates gets off scot-free. I'm delighted to introduce as moderator Bob Langer, who is currently a partner at Wiggin and Dana as head of their antitrust and trade regulation practice group. having worked for many years as the principal in the Connecticut Attorney General's office on antitrust and consumer protection, who served as chair of the National Association of Attorneys General Multi-State Antitrust Task Force earlier in this decade before going into private practice. His credits are numerous, including advisory board of the BNA Antitrust and Trade Regulation Report, Board of Editors of Matthew Bender Antitrust Report, and he himself is the author of a 2-volume treatise on one of the great blunderbuss state statutes, the Connecticut Unfair Trade Practices Act, out of which he made a living for a number of years. When I, and you continue to read it, I joined this faculty in 1971, which is very nearly before the flood. And Bob was, nominally at least, a student of mine in a seminar my first year in the faculty. I wouldn't want to think too carefully now as to who was teaching whom, but the relation has continued with great pleasure on my part for many years, and I'm glad to have it continue today, as I expect to learn more from him now, even than in the past. Bob?
And we look the same as we do today, Hugh. Yeah, it's quite remarkable. My firm in particular welcomes you. We are really privileged to be able to put on this symposium. All of the credit, however, belongs to the Connecticut Law Review, who did all of the work. In particular, Peter Burrill and Danielle Ferrucci, who are the symposium editors, deserve enormous credit for first attracting such extraordinary group of speakers. Having practiced in antitrust for over 25 years, to assemble this group is really terrific, and I'm sure it will lead, whether the case settles or not, to quite significant debate regarding the future of antitrust in this country. I want to acknowledge, as Peter has, one of my great friends, Steve Rutstein, who is the head of the Antitrust Consumer Protection Department in Connecticut, has played a central role not just in Microsoft litigation, but in multi-state cases throughout the last 20 years, and Steve and I work together forever. Lynn Gelzo and Rachel Davis are also Assistant Attorneys General are here, and if I can draw them out later, one of us can draw them out regarding the state-federal issue, which hopefully will get addressed sometime during the day of the symposium. I hope that will occur. By the way, unfortunately, Professor Harry First of NYU will not be speaking today, and he will not be speaking not because he's ill, but because he has taken a position as head of the Antitrust Bureau in the New York State Attorney General's office under new Attorney General Elliot Spitzer, and thought it would be inappropriate for him at this point, considering New York's central role in the matter, to speak on the subject, since he has actually not taken his position yet. In addition, Will Roger of Interactive Week unfortunately called yesterday and is quite ill and could not make the trip, and that is also unfortunate. I will try to, despite my the fact that I've been a professor for 20-something years as well and tend to ramble off at the mouth, will try not to do that and to maintain my moderator role. My partner, David Fine, is, if you've read the program, is Special Investigative Counsel to the Antitrust Division in the Microsoft matter, and while we do have a firewall between us and we don't discuss the matter, it would be, I think, safer for me to ask questions rather than try to even opine upon answers. Let me just raise possible issues that could be discussed today from our panelists in just a minute or two, and then I'm going to get out of the way. Peter mentioned, cases of the century. I think one of the questions is Microsoft one of the cases of the century, equaling in importance cases such as Standard Oil and Alcoa, or is it a blip? I mean, is it important substantively, or is it only important in this particular market? And I think the questions are not clear. The question is clear. The answer is not at all clear. Can and should existing antitrust jurisprudence be applied to high technology markets in which Microsoft and its competitors operate? Is there something different about barriers to entry, about entrenchment, about the exertion of market power with regard to high tech, or is it simply the same as steel and oil and tobacco and any number, and aluminum ingots, or any number of other cases? If Microsoft, and this isn't a subjunctive, Rick, were found to have violated the law, is there an antitrust remedy available to the court? And if so, is such a remedy likely to make the market more competitive or not? At least two of the speakers today, Professors Kovacic and Detrain, are going to specifically address those issues, and I expect others in the dialogue we're going to have at the end of the morning and the afternoon to do the same. What impact is the Microsoft case likely to have upon future coordinated federal-state antitrust enforcement? There is the highest level of coordinated activity between the state and federal enforcers in the history of this country. Is that likely to continue? What effect will Microsoft have? Can we not know that until the case is over, or is this portend the future of what I've suggested in some articles of my own about a more formalized allocation of responsibility between various sovereigns? And finally, in my favorite question, which is only done I preface this as not to become incendiary or to incite a riot, but to raise this following question. It is well known that Section 2 of the Sherman Act prohibits both acts of monopolization and attempts to monopolize, and the speakers will speak about that today. It's less well known that Sherman 2 is a criminal statute in which an individual, as you may not know, is subject to imprisonment for up to 3 years, and a corporation is subject to a fine of up to $10 million. And so the clever question, which doesn't really do justice to the issue, is could, and if so, should the Antitrust Division have sought the indictment and conviction of Bill Gates? The real question is there a role for criminal enforcement in the area of monopolization? And unfortunately, having known Rick Rule as I have and known his writings in the area, both when he was head of the Antitrust Division and afterwards, he's actually thought deeply about those issues and opined upon those questions. What the format's going to be is we're going to have speakers this morning. I've spoken to each about not doing extended introductions, part because the law review has been kind enough to include the bio sketches. But I do just want to just introduce the panel briefly, and including the speakers that are in the audience who will come up at the end of the morning in time for the panel discussion. Bert Four is president of the American Antitrust Institute, an independent non-profit think tank that was just founded in 1998 and has already had a quite significant impact in this country. I know personally because one of my clients, who I've mentioned to Bert will remain anonymous, asked me in the course of an evaluation of an appellate court decision we were looking at, what's the likelihood that we'd find Bert as an amicus in this matter? And so he obviously has gotten on the radar screens of some very large companies very quickly. Bill Kovacic is professor of law at the George Washington University Law School in Washington, D.C. I've known him for many years. He is one of the finest speakers I've ever come across, and is extraordinarily thoughtful, and looking forward to his comments, particularly about remedies. My friend Rick Rule, who was head of the Antitrust Division from 1986 to 1989, and we worked, despite all of the conventional wisdom to the contrary, worked extremely well together during that period of time in a vast array of matters, is partner in Covington and Burling now and head of its antitrust and trade regulation practice group, and will speak about whether Microsoft has in fact violated the law, and his firm does represent the company. Professor Leonard Orland, who was my mentor when I went here, the only reason I ever got involved in antitrust was because of him, and I owe him a debt of gratitude, or some businesses probably think from my prior life they should never have been introduced to him. But he has been teaching antitrust law here at and other courses at UConn for many years, and is widely known and respected for his authorship of an extraordinary array of books. And he's going to deal with a very interesting topic about how you teach Microsoft during the course of the litigation, which he did. And I'm very pleased that Lenny could be on the panel. Very briefly, Bob Levy is in the audience. He's a senior fellow in constitutional studies at the Cato Institute in Washington, D.C., and he has a particular view about the role of antitrust, is very thoughtful on this subject, and I expect that there may be some differences of opinion regarding his views and those of others. And I'm extremely pleased that he agreed to speak here today. Professor William Page, professor of law at the Mississippi College School of Law, is front row here, and again, it's a privilege that he was able to be here today and had a tenure in the antitrust division and has written extensively on these subjects. Jonathan Zutrain, I used to see well. There he is. Executive Director of the Berkman Center, if you could just raise your hand, but you'll be up here later. He is Executive Director of the Berkman Center for Internet and Society and a lecturer on law at Harvard Law School. And again, he has thought deeply about these issues, and we are fortunate that he's here and look forward to his presentation. And I'm going to get out of the way and allow Bert Ford to take over.